So before we can look ahead to what employment law changes are coming up in 2024, we first need to look at what's already been introduced this year. So from the 1st of January 2024, the working time regulations meant that businesses no longer have to keep a separate record of the daily working hours of their workers, provided that they're able to demonstrate compliance without doing so. So we do, however, urge you to consider whether your employees work elsewhere, as this will obviously impact upon the hours they work in total. And we're going to cover carryover leave and normal pay rate in more detail on the next slide. Additionally, on the 6th of January, national insurance rates were cut in the following categories. So were cut by 2% from 12% for those earning between £12,570 and £50,270. And self-employed workers now pay 9%. Class 2 national insurance for the self-employed was also abolished. On the 27th of January, the Employment Tribunals and Employment Appeal Tribunal Regulations 2023 came into force. The impact of the change means that it's likely that most employment tribunal cases will be heard by a judge sitting alone. And it's also likely that most appeals sorry, I'm just letting a few more people in. There's a couple of late people. So it's also likely that most appeals in the Employment Appeals Tribunal would also be dealt with by a judge sitting alone. In February 2024, so from the 13th of February, fines for employing illegal workers increased in cost. These are now £45,000 per worker for breaches and £60,000 for repeat breaches. So alongside the rise, the UK Home Office issued updated guidance for employers. When carrying out right to work checks, you need to check everybody, not just those with a foreign sounding name, because that's actually discriminatory. And it's important that you do not allow anybody to start work for you until they have done the necessary checks and you've got the paperwork. And in some cases, this might mean delaying their start date or withdrawing an offer of employment. Let's move on to March 2024, where the spring budget took place on the 6th of March. And it was discussed about national insurance contribution rates. Again, they've been cut from 10% down to 8% starting in April. And the government has also extended 30 hours of free childcare to children over 9 months old. And that's going to be introduced in a staggered approach. So we'll give you more detail when we know about that. And from the 31st of March 2024, the emergency COVID carryover leave rules implemented in 2020 were removed. So please note this cannot be paid out as a monetary sum except on termination of employment. So please make sure that your staff use their leave if they've still got that to use up. Next slide, please, Beck. So following on from the last slide, we're now going to talk about the working time regulations and holiday. I'll give you a few minutes just to read through what's on the screen. Why is this change happening? The government have introduced these reforms to simplify holiday entitlement and holiday pay calculations. So what do you need to do now? When calculating holiday pay, employers need to ensure that any holiday pay includes not only an employee's basic salary, but also any regular overtime that they usually work. And it's also a good idea to regularly remind staff to take their holiday at intervals throughout the year to comply with your obligations as their employer. Next slide, please, Beck. So let's look at what employment law changes are coming up in the next few months. There's a whole host of changes planned for April this year, which we're going to cover in detail in today's webinar. So what does this mean for HR and HR practitioners? The failing to comply with employment law does not only carry a threat from employees, such as from costly tribunal claims. In extreme cases, it can also lead to prosecution, which can be damaging and costly for any organisation. So employment law controls the relationship that employers have with employees. It governs what employers can expect from their employees, what employers can ask employees to do, and employees' rights at work. So it's there for a reason, which is why we've got such detailed slides on it today. So next slide, please. So from the 1st of April this year, the national living wage will be applied for the first time to those aged 21 and over. It will also achieve the target first set by the government in 2019, and this is the largest increase ever in the minimum wage in cash terms, and the first time it has increased by more than £1. So please note that if a HMRC finds an employer has not paid the minimum wage, then they can take the following actions. They can issue a notice to pay money owed, going back to a maximum of 6 years, and they can issue a fine of up to £20,000 and a minimum of £100 for each employee affected. And the government have recently started to name and shame employers who do not pay the national minimum wage to their staff, which is obviously quite bad for your reputation if you're caught out. So what should employers do now? Review your hourly rates to make sure that you are paying your employees the correct rates. Because not everybody means to make a mistake, but obviously mistakes can be costly. And when deducting monies, ensure the deduction does not push your employees' pay below the national minimum wage or national living wage. So when you've got a leaver and they've got a training agreement in place and you're taking that money back, just think about what their take-home pay is and how much they're getting, because that will have an effect. Next slide, please. So the first changes to take effect from the 1st of April are changes to holiday rules. So for holiday entitlement, for holiday years beginning on or after the 1st of April 2024, holiday entitlement will be calculated using an accrual method throughout the holiday year. And in terms of rolled up holiday pay, it's going to be allowed for irregular and part-year workers only. This means paying an additional amount of holiday pay along with basic pay throughout the employment relationship. So instead of just making a payment at the time the holiday is taken, you pay it throughout the year, basically. It will not be compulsory for employers to implement rolled up holiday pay, but they can choose to do so if you wish. So what do you need to do now? Employers should review their current holiday policies, educate their HR and payroll teams about the changes, update your systems, and communicate these changes clearly to your employees. Next slide, please, Beth. So the changes to the holiday rules on this slide apply to all workers. That was slurp my drink. Well, I'll leave you a minute to read that. So for family-related leave, workers who have been unable to take holiday due to being on family-related leave must be allowed to carry over any unused holiday. This applies to those who've been on maternity leave, and that's sort of shared leave, basically. Next slide, please. So the introduction of carers leave regulations 2024 is a brand new statutory right from day one of employment. And it's important to note that the person being cared for doesn't have to be a relative. That can be a friend or even a neighbour, and the employee does not have to provide evidence of their dependent's care need. The carers leave is unpaid, and we strongly advise you to keep it that way, not to make any exceptions to the rule here, because that could lead to abuse by employees of the new right. If the employee cares for more than one dependent, they're still only entitled to 1 week of carers leave and cannot request a week for each dependent. And the notice does not have to be put forward in writing, but we encourage employees to submit their request in writing so that you as the employer can keep a handle on things and manage the leave effectively. Employers cannot refuse a carer's leave request, but they can ask the employee to take it at a different time. They can only do this if the employee's absence would cause serious disruption to the organisation. So if you delay it, the employer must agree another date within 1 month of the requested date. And they must put the reason for the delay and new date in writing to the employee within 7 days of the original request and before the requested start date of the leave. So what do you need to do now? So ensure managers are trained in the new policy and procedure and how to manage these requests. Add the new policy to your company handbooks. Make sure everybody in your organisation is aware of it, and keep a record as to when leave has been taken to ensure that you can manage the leave. Next slide, please. Again, from the 6th of April, the flexible working amendment regulations come into force. This removes the requirement for employees to have 26 weeks service in order to make a flexible working request. So it means they've got a day one right from the 6th of April. So it'll also probably encourage job applicants who are not put off by the working hours. And a request can only be refused if the reason falls into one of 8 permitted reasons of refusal, which are burden of additional costs, detrimental effect on the business's ability to meet customer demand, detrimental impact on quality and performance, unable to organise work amongst existing staff, unable to recruit more staff, or insufficient work during the period the employee wishes to work, as well as planned structural changes. The employer must provide evidence to support the reason for refusal. Remember that that's the right to request, but not the right to have. So the time to deal with the request, including the appeal, will reduce from 3 months down to 2 months. So if the request is not dealt with within this time frame, the employee can be awarded compensation at employment tribunal. And we're asking you to note that there isn't a statutory right to an appeal, but ACAS do recommend incorporating this, as do we, because it can help employers to get a bit of a heads up regarding any employees who may feel aggrieved by the process. So it allows you to sort of head it off at the pass, really. So what do employers need to do now? Training managers on the changes to the regulations is essential. Review and update your flexible working policy and procedure to ensure they reflect the new regulations. Be wary about asking related questions during the interview process. This is quite a big one. For example, will you be submitting a flexible working request when you start work? It's a no-no, I'm afraid. So please don't use that wording in future interviews because you don't want a potential claim on your hands. Next slide, please, Beck. So from the 6th of April, there's lots of legislation changes, isn't there? We've got Protection from Redundancy, Pregnancy and Family Leave Act 2023. And this comes into force. However, this protection only gives employees priority for redeployment opportunities. So it's not a ban on making employees redundant during the special protected period. It's just giving them priority status so they can still be selected for redundancy. The protection kicks in when it comes to the allocation of alternative roles. Next slide, please, Beck. So for clarity, this table taken from Lewis Silkin summarises how the length of protection works in practice. So top practical tips for employers. Number 1, have a robust system in place so that at any point it is easy to identify which employees have priority protection and the dates when this starts and ends to limit inadvertently falling foul of obligations. So establishing those that may have priority may not always be straightforward or known straight away, which is why you need a system for this. Be prepared for earlier notification of pregnancy and potentially an uptake in employees taking shared parental leave after the 6th of April. Number 3, ensure managers as well as HR are aware of the changes and what they mean. The fact that some employees have priority over others, alternative vacancies can seem unfair to employees who don't when a redundancy situation presents itself. So increasing awareness of the rules can help employers manage the situation if any redundancy scenarios should occur. Introduce guidelines for helping to consistently assess whether a vacancy is a suitable alternative, and consider the issues of alternative roles and priority from the outset of redundancy planning. So if you make your employees aware of this protection now, communicate it to all staff, should you ever have a situation in future where it will apply, everyone's aware of it already. Next slide, please, Beck. So let's talk about the Paternity Leave Amendment Regulations 2024. It's important to note that the regulations came into force on the 8th of March 2024 to allow parents of children born or adopted on or after the 6th of April to give the required 28 days notice. So it's actually in effect now, but it applies to those children born or adopted on or after the 6th of April to give the notice. So what do you need to do as employers? You need to update your paternity leave policies, so more policies to be updated. People managers may need updating on the new rights. Employers should also consider what level of payment they want to make for statutory paternity leave as a matter of their policy, because offering full pay is becoming increasingly the norm. Slide, please, Beck. So again, 6th of April, the Employment Rights Increase of Limits Order 2024 is due to come into effect, which prescribes the annual increase in compensation limits for employment tribunal awards and other statutory payments. I'm going to hand over to my colleague Natalie, who's going to guide us through the rest of the presentation. Over to you, Natalie. Next slide.
Thanks, Kim. Thanks, Kim. So from the 6th of April, there'll be a number of increases to be made to statutory payments, which can be seen on the screen. So when you're calculating the statutory payments for any employees on family-friendly leave or who are currently receiving statutory sick pay, then please make sure you use the new rates during your calculations. Next slide, please, Beck. So here is an overview of the upcoming employment law changes, which I will now go into more depth on the following slides. Next slide, please, Beck. From the 1st of July, the TUPE Regulations 2023 will bring in a new rule to permit employers to consult directly with staff affected by TUPE, rather than the current requirements where you have to elect employee representatives. This applies to businesses with fewer than 50 employees or where the transfer involves 10 or less employees. Going forward, this will hopefully make it much easier for you to consult with your employees who are being TUPE'd into a new organisation. And please note that this change is for TUPE transfers on the from the 1st of July. Next slide, please, Beck. So another new act coming in on the 1st of July is the Employment Allocation of Tips Act 2023. This new act provides transparency and fairness across the board when allocating tips, gratuities and service charges. Please note that this only applies to qualifying tips where the final distribution of tips is controlled by or influenced by the employer. So any tips that are received directly to the employee and where the employer doesn't have any control of the allocation is not within the scope of the new act. So going forward, employers will be legally required to allocate tips fairly and transparently, pay tips within 1 month of when they were received. You will need to implement an allocation of tips policy, which is readily available to all employees. And you will also need to record tips distributed, which again will need to be made available to employees should they wish to see this. Failure to comply with the Act can lead to an employment tribunal claim, so the government has issued a new statutory code of practice to help businesses comply with the new obligations. Next slide, please, Beck. From the 8th of September, the Workers' Predictable Terms and Conditions Act will be implemented. So this will give employees who are on atypical contracts, so agency workers, 0-hour workers, or those who are on a fixed term contract, will have the right to request a more predictable working pattern. And this can refer to having a set number of hours a week, set days, or certain times during the week. For those on a fixed term contract, they can also request a longer contract. So this act has been implemented to promote fairness and stability in employment for both the employee and the employer. So what are employers required to do? You will need to implement a predictable working pattern request policy. You will need to deal with any requests within 1 month, which is included in the appeal process. So the timeframes are very tight, which is why it's going to be really important that you train your managers to make sure that they are aware of their obligations. This policy will also follow the same procedures as the flexible working requests, with the exemption of the time that you need to deal with it. And as always, the ACAS have drafted a code of practice which will enable you to have further information of how to deal with requests. Next slide, please, Beck. So from the 26th of October, the Worker Protection, which is an amendment of the Equality Act 2010, will be enforced. So this act will employers must take reasonable steps to prevent sexual harassment in the workplace. So employers will be required to review your equal opportunities, harassment and bullying policy to make sure it includes the new rules. You will need to have a clear process on how to report the harassment, which again will need to be made available to all employees. You need to review your record keeping to ensure the harassment reports are logged and comply with data protection. And you will need to train both managers and employees on the changes, particularly managers who will be dealing with harassment reports, to make sure that they are following their legal obligation. It's important to note that if reasonable steps are not taken to prevent sexual harassment, then an uplift of 25% of compensation can be given at an employment tribunal. Next slide, please, Beck. So just as a heads up, here are a number of proposed changes on the horizon. We don't currently have any information about the dates that these will be implemented, but we just wanted to make you aware. So a new statutory code is going to be introduced regarding the fire and rehiring, which is a practice where employers can dismiss workers and subsequently rehire them under new and often less favourable terms and conditions. Although this isn't illegal, it is very controversial and has drawn significant negative attention within the last couple of years, particularly with the P&O scandal in 2022. So this new statutory code will be introduced to emphasise meaningful consultation with your employees. The Bullying and Respect at Work Bill proposes to introduce a statutory definition of bullying and will allow employees to bring a standalone claim for bullying at a tribunal. This bill has its second reading on the 7th of June. A new law to increase the break needed to end continuous employment from 1 week to 4 weeks is to be introduced. GDPR will be replaced with a common sense data protection system. Further details of the proposed new scheme is yet to be released. The government has also proposed a new law to limit the length of non-compete clauses to 3 months. And finally, where the exemption from gender pay reporting will be extended to businesses with fewer than 500 employees. Currently, this exemption only applies to businesses with under 250 employees. So as I said, we currently have no dates of when these will be introduced, but we will continue to update you on any future changes. So in summary, there are a lot of changes to be introduced in 2024. So please do make sure you take the opportunity to do your housekeeping to stay ahead of these changes. So you'll be required to review your policies, procedures and handbooks to reflect changes. Make sure that you communicate these to your employees and to train your managers on the changes and how to deal with policies effectively. Next slide, please, Beck. So before I move on to RBHR, does anyone have any questions? No?
And if you can't think of anything now, we can always you can always fire them at us later on. So we're quite happy to deal with any questions afterwards.
Next slide then, please, Beck. So if any of the changes that Kim and I have talked about today are concerning you and you're not already an RBHR client, then please do get in touch with us. We offer 3 different services which can help you, either via the HR Time Bank, where you can purchase a set number of hours starting at 12 hours. There's the HR Retainer, or we also provide training where we also offer bespoke training to clients which are tailored to specific needs. Next slide, please, Beck. So whilst we have a significant portfolio of training courses, I wanted to highlight 2 courses that have been created due to the increasing number of issues we have helped our clients with over the last 12 months. The first one being mental health first aid training, which is being created in response to a growing need for our clients to support their employees' mental health. This course enables managers to manage mental health in the workplace by spotting the early signs of poor mental health, how to offer and provide initial help, and how to encourage a person to seek professional treatment and other sources of support. We currently have spaces on our refresher course on the 21st of May, or if you haven't attended one of these courses before, we are offering the 2-day course on the 4th and 5th of June. Next slide, please, Beck. Another growing area of issues which we've seen with clients and at employment tribunals is respect in the workplace. So we have designed a Respect at Work training programme, which is the first step in protecting your business. This lasts for an hour and a half. Respect at Work is going to be particularly important with the new Workers Protection Act coming into force in October. So if you're interested in hearing more about the training more of these training sessions, then please do feel free to drop us a message and we can provide you with more information. Next slide, please, Beck. You'll probably need to click it again. So thank you for joining us today. We'll be sending out the slides and a copy of the recording to you all. And we are going to be holding another employment law webinar in October, as there's a lot more changes coming into place. So we will provide more details on this nearer the time. So please watch this space. And thank you for attending.
Thank you, everybody.